Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here with another lecture regarding our area of contracts. And in this one, we're going to look at the key concepts and applications of third-party contracts. So we'll look at the fundamentals of third-party contracts, types and purposes of them, examples will be provided. I'll explain vesting of rights in these types of situations, assignments in general, how it's done, and the effects and the revocation. Also issues that evolve from multiple assignees and legal requirements surrounding that. So we're going to talk in this lecture about third-party contracts, and the simple way is to give you the idea of what a third-party contract is. It's a contract where somebody who wasn't a party to the contract but gets some sort of benefit from it or has something related to it. And we'll see the different types. So most contracts that we've talked about in most situations in general are between two parties. They may be two people or two businesses or a business and a person or a party, but there's those two people. They negotiate for the contract and the contracts between them. Sometimes we have a situation where a third party receives their consideration, the consideration of one of the parties that's involved in the contract, or they actually perform one of the contractual promises instead of the original party. So if you think of it as we might have let's say these two people, and they have a contract. You know, this lady and this gentleman, and after the fact, this third party either performs one part of the contract or gets a benefit from it, and sometimes it's planned for when the contract is entered into, and sometimes it's later. Sometimes it's to pay a debt, sometimes it's for a gift. So we'll need to learn about those different ways. Generally speaking, the original intent, if the original intent of one of the parties to the contract is to have the consideration that they would normally get under the contract, have passed it to a third person or to go to some third party. And that's a common type of third-party contract. And so the question is why? Why would you want to do that? Well, we might have an intent at the time of the contract, might have an assignment after the contract that's needed, or a third party and looking at their enforcement rights. So next we'll look at the types and purposes of third-party beneficiary contracts. First of all, it could be that you're a party to this contract, but you owe money to somebody else, some third party. So you're just going to let whatever money might be coming your way to you in this contract, you're going to have them pay it to the person you owe to satisfy your obligation. That's what's called a third-party creditor beneficiary. That situation is where you're extinguishing a debt or obligation already owed to a third party, which means the debt is in existence at the time the new contract is entered into. And you're aware of the debt, and so you make the terms of the contract where the consideration that usually would come to you is going to this third party creditor to pay off what you owe them or extinguish your debt to them. The second type could be for trying to give care or gifts. Planning on giving a gift to some third person might be your goal. And this is a third-party donee beneficiary. You don't owe any money. You don't have a debt to this third person, but you want to give them something. So you're trying to confer a gift on them as a third person. Those are the two scenarios that you might have. The key here when looking at a contract and determining is this a third-party contract to the third party, or the parties is the question. What type is it? We have to look at the intent of the parties when the contract is formed. So at the time they are forming this contract, it must be clear that the purpose of the contract is to benefit a third person, at least for one of the parties to benefit some third person, not a party to the contract. So this third party is not a party to the contract, but they're going to get the benefit from it. And part of it, the intent must exist at the time of the contract. But the intent must confer either a gift or be there to satisfy a debt for a third party at the time the contract is entered into. If, however, you're talking about a scenario where the contract's entered into between two people and there's no thought of a third party at that time, but later on one of the parties decides they want someone else, some third party, to get the benefit of this contract or that sort of thing, that's something different. That's called an assignment. And so we'll talk about that a little later, but keep in mind we have to look at what the intent of was the parties at the time the contract is formed. Remember that the third party is not a contracting party. They're not a party to the contract. However, depending on the situation, they may have some rights and could go to court to have the contract enforced. And this will just depend on the situation, the type of contract, and what's happened. Next, we'll give some examples. We've got Jack, who owes Jill $500, and he doesn't have the cash to pay Jill, but he does have some furniture, so he's entered into a contract to sell his sofa and love seat to his friend Andy for $500. And as part of the contract, at the time they negotiate for the sale of the furniture, and the $500 being the consideration here, Jack tells Andy that he wants the $500 not to come to him, but that Andy would just pay it to Jill. So Jill's going to be the third-party beneficiary of this contract, and Jack is using this contract to satisfy his consideration. But it would be coming his way to satisfy the debt that he owes to a third party, and that would be Jill. So what kind of contract is this? Is this a third-party creditor beneficiary contract or a third-party donee beneficiary contract? Hopefully your answer was that this is a third-party creditor beneficiary. Yes, they're using this to satisfy debt, so there's a creditor here. So let's look at another example, and that's about Larry, who enters into a contract with Jessica for Jessica to clean his mom's house as a Mother's Day gift to her. And Larry's going to pay Jessica $200, and Jessica's going to clean Larry's mom's house, and that's going to be Larry's gift to his mother on Mother's Day. So the third party here is the mom, Larry's mom, because she's getting the benefit or consideration in this contract. Larry's paying the $200 to Jessica, and that's the consideration he's giving up, and Jessica is cleaning the mom's house. So what kind of contract would this one be? A third-party donee or a third-party creditor beneficiary contract? All right, hopefully you said third-party donee contract because you see here's a gift and that's what you're looking for is a donee beneficiary contract. Another example here would be a student loan. You apply, you're a student, you apply for a loan from a bank, and the bank says we're going to loan you the money. We're going to grant you the loan, and the school that the student that you go to, you go ahead and enroll in classes, you get admitted by the school, And this is all based on the bank's promise. The bank's promise to loan the money. But a few weeks into the semester, the bank decides they're not going to loan the money. They cancel the loan. They're not going through with it. And the contract here is between the student and the bank, right? It's a loan contract. They borrow money. The bank gives them the money. The student has to pay it back with interest. That's the nature of the loan agreement. The third-party creditor beneficiary here is the school. And they've admitted the student, which means they've not admitted another student. If somebody else has been admitted, that might have actually, that might have had the money to pay it. And second, so the school's looking at it like, I let a student in, and someone else could have gotten in who had the money. And second, there's a spot in the class, and you've been attending the class, and the school's been paying the instructors. So the school's relied on this promise from the bank, even though they're not a party to it. They're third-party creditor beneficiary to it, and that would be a vested interest. And we'll go into more vesting stuff right now. So let's do that. Vesting rights in third-party beneficiaries. So with all that in mind, let's look in a little more detail about some of the common law that applies to these contracts. If it's a third-party creditor beneficiary contract, which means that they're using this to pay one party, using this to pay a debt, first of all, for that to be the case, the debt has to exist prior to this new contract. So you must already owe the debt. If you don't owe it, and later you're changing the contract, that's going to be an assignment, like I mentioned earlier. Now, the creditor to this is what we would call a real party in interest, and they may be entitled to enforce the contract if their rights have what we call been vested. And what we mean by enforce the contract is to go to court and have the court order that the parties do what they're specified to do in the contract. Now, how do we determine whether someone's rights have vested, where the third-party creditor beneficiary has their rights, whether they're vested or not? And the key to this is, have they relied on the promise to their detriment? Have they relied on it to their you've seen this language before. It's called promissory estoppel. So we're going to be looking to see the third-party creditor beneficiary act in some way, do something in reliance on getting this money or consideration, whatever, the furniture, whatever it happens to be, to their detriment. And if so, this right vests, and he could go to court and have the contract enforced if one of the parties wasn't doing what they're supposed to do. Now, if it's a donee beneficiary contract that you're talking about, vested means simply that the donee finds out or learns the existence of the contract. They know the contract. They've been told somehow or informed. However, their rights may have vested, but unless they've got some detrimental reliance here, they've relied upon it to their detriment, then they're not going to be able to sue for breach of contract. So an example here is Barney enters into a contract with a florist to deliver flowers to Betty on Valentine's Day. The day before, Barney tells Betty to expect the flowers, and Valentine's Day comes and goes, and they're never delivered. So the flower shop for us has essentially breached their contract with Barney. The question is Betty a third-party beneficiary, and does she have rights to sue under that? Well, her rights have vested, haven't they? I mean, she's learned the existence. Barney told her the day before. And, however, not sure they'd be in any detrimental reliance on this little scenario. So that's what you need to look for. And if it's a donee beneficiary contract we're talking about, vested means simply that the donee finds out or learns of the existence of the contract. They know of the contract. They've been told somehow or informed. However, their right may have vested, and they've got some detrimental reliance here, as I just talked about. And, so this little scenario probably wouldn't go very far with the flowers, but that's the difference between a donee and a creditor beneficiary. We're going to look next to assignment of contractual rights. An assignment, as I mentioned before, it takes place when a contract already exists between two parties, and later on, sometime after that contract's been entered into, one or both of the parties transfers their rights under the contract to some third party. And this comes into existence after the original contract is made. And you can't, however, assign your rights under the contract without the other party to the contract knowing about it and saying that's okay. So it either has to be in the language of the contract. It says the parties can have another party come in and actually fulfill the contract, or have the rights to consideration, or something, or other, or implied under the circumstances. You can only assign your rights, not your obligations. So that means whatever is coming to you, whatever consideration is coming to you as a party to your contract, you can assign that to someone else. And you could say somebody else can get the benefit of this contract. However, you can't assign your obligations, which is what you're supposed to do under the contract, what you're contractually obligated to do, whether it's paying money or something like that. So there are some limitations that come into play here. The assignment of rights requires express or implied consent from the promisor before proceeding, and only rights can be assigned, like I was just pointing out. Obligations cannot be, and personal service assignments are prohibited if performance depends on some personal competence or recipient of the circumstances. So let's look at some examples. Jennifer and Tessa enter into a written contract for the sale of Tessa's RV for $2,000. And before Tessa delivers the RV, Jennifer tells her she really wants to give the RV to her parents as a gift and asks Tessa to deliver it to them instead of her. This is a good example of an assignment because these two people, Jennifer and Tessa, have a contract. At the time the contract's entered into, there's no thought or intention or discussion or whatever else of the parents. Later on, before delivery takes place, Jennifer tells her she wants the RV to go to her parents. So she's intending to give them a gift. She's assigning to her parents the right to get this RV. Here's another example. Ben owes Henry $500 under a loan agreement. So after the contract's entered into, with Henry for $500, Ben needs to pay it back. So he owes him money. Then after the agreement, Henry learns he owes Chris $250 for some reason. And Henry assigns to Chris $250 of the money he's going to get from Ben. So he assigns that over to Chris to settle his debt to Chris. So he simply says, I'm going to assign half my repayment here to go to Chris to settle that debt, and the other half would come to him. I use this example to show you can split a portion to assign instead of assigning an entire contract. We'll look next to the creation and validity of assignments. First of all, it's fine for an assignment to be oral or written. However, if it falls under the statute of frauds, real estate, marriage contracts, sales over $500, over 1 year to perform a service, those are situations that require they be in writing. They need to be formal contracts according to the statute of frauds. Assignments related to those contracts would have to be in writing. It can also be a gift, or it can be something to fulfill an obligation under another contract. Would be like a debt or something like that. Either way, the assignor is the one making the assignment and can make full or partial assignments to the assignee. So it can be assigning the whole rights under the contract or part of the rights, like we talked about earlier. So turning back to the guy that was assigning 250 from the 500 he was owed from someone, and then he later assigned that 250 to another person. So keep in mind that you cannot assign a personal service. So if this is something where you're providing a personal service to someone, like maybe cutting hair or working or, something like that, or if the performance is dependent on someone having confidence in the person of the particular circumstances of the recipient. So this is just like widgets or something or money. It's no big deal if that's the case. But if we're talking about a personal service where somebody wouldn't necessarily want to have to be obligated to perform that personal service for somebody else, instead of doing my hair, I'll do my friend's hair or something like that. That's not allowed in an assignment. If an assignment is created and it's valid, then the assignee becomes a real party in interest, meaning they have rights under the contract. They're essentially part of a new contract. With consent, consent of the promisor and contract clauses on assignment. With consent of the promisor, what actually has to be the consent of the original promisor. And that's since the assignment actually will change their obligation under the contract. So they need to be okay with it and give their consent. And most contracts are assignable under the law unless, of course, it's going to materially alter the source of obligation or duty. So let's say this was a contract to paint your house, and you were going to pay $500, and you say to the painter, now I'm going to assign my rights from my house being painted to my friend. If that person's house is 10 times the size of your house, that clearly materially alters what the person has to do. So that wouldn't be allowable under an assignment. You can also have a clause in the contract that deals with assignments. In most business contracts, they're going to have that. And what you mean by that is you can have language in the contract that either says you can have assignments, you can't have assignments, which would be prohibited, or maybe setting the terms for how an assignment is made. All these sorts of clauses can be placed in there regarding assignment. What are the circumstances and how to do it. So what are the effects of and the revocation of assignments? What do they look like? Actually, if done properly, it assigns or transfers the assignment rights under the contract to the assignee. So the new person gets the rights under the contract that the original party of the contract had. That's what we mean by assigning. If the assignment is made for consideration, meaning the third party assignee is giving some consideration to the assignor for the assignment, then it's irrevocable. If it's just a gift situation, if it's gratuitous, it's always revocable, unless it falls under one of these little categories that wouldn't be revocable here. And these are, you'll see some terms here, estoppel, where we talked about before, we're sometimes relied on to the detriment. If performance has already occurred, it cannot be assigned, and so on, and so it's still going to be non-revocable. A token chose is something symbolic of an assignment, like just a little token or something that symbolizes it. If that's done, then you cannot revoke it. Novation is a situation where you're essentially substituting the parties to a contract, and that's basically all parties, and the parties must agree to that. And these are, again, you'll see these terms again, estoppel coming up. And all of these things make a difference as to whether it's assignable. So issues with multiple assignees and legal requirements. When there are multiple assignees, sometimes we can create some confusion as to which one prevails, which one actually has the assignment. The usual rules are the first in time, again, kind of like in real estate, unless a later signing has a greater equitable claim. So generally the first one to get the assignment is the one that actually has it if there's an issue. And if it's a UCC situation, it requires assignees in certain types of contracts to file something called a notice of claim with the state or county. And that will be filed so that other people know there's a notice of claim. So to conclude this presentation, we explored the fundamentals, types, and practical examples of third-party contracts, including creditor and donee beneficiaries. We examined the vesting of rights, assignments, and the legal implications of multiple assignees. And understanding these concepts is essential for navigating contract law and ensuring proper enforcement and protection of third-party interests. And thank you.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.